The title of this week's Brandon's blog is Forgiving Student Loans Through Canadian Bankruptcy, the Supreme Court's Game-Changing Piekut Decision. This Brandon's blog provides an overview of Canadian bankruptcy concerning the discharge of government student loans, focusing on the impact of the Supreme Court of Canada Piekut case decision released on April 17, 2025. Brandon explains that previously, differing court interpretations existed regarding when the mandatory period for non-discharge of student loans began after periods of study. The Supreme Court's decision established a single-date approach, meaning the 7-year waiting period before student loans can be discharged through bankruptcy commences only after a borrower's last instance of being a full or part-time student, even if no student loans were involved in their final stint as a student. Brandon further discusses the possibility of earlier discharge via a hardship application after 5 years and clarifies that the rules do not apply to private credit advances for the purposes of studying, only to federal and provincial student loans. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. If you or your company has too much debt and you cannot find a solution to get out of your financial problems, shoot us a message, give us a phone call. Brandon and myself are available to help you using new, innovative methods. We would love to speak with you.
Hi there, I'm Fiona Ledger from Ira Smith Trustee and Receiver Incorporated, a licensed insolvency trustee firm helping Canadians navigate their financial challenges. Today, I want to explain how a recent Supreme Court of Canada decision affects your student loans if you're considering bankruptcy. If you're struggling with student debt after your undergraduate program, you should know that government student loans are treated differently in bankruptcy than other debts. The general rule is this: your student loans cannot be automatically discharged through bankruptcy if you file within 7 years after you stop being a student. But here's where things get complicated. When exactly does that 7-year clock start ticking, especially if you've gone back to school after your undergraduate degree? The Supreme Court recently answered this question in a case called Piekut v. Canada. Ms. Piekut had attended school multiple times between 1987 and 2009. She filed for debt relief using a consumer proposal in 2013 and argued that her student loans should be discharged because it had been more than 7 years since she received her last government student loan in 2003. However, the Supreme Court ruled that the 7-year period only starts after your very last period as a student, in her case, 2009, even though she didn't take student loans for that final program. What does this mean for you? 3 important things. First, if you go back to school for any reason, even for a single course that qualifies as part-time studies, your 7-year clock resets and only starts running again after you finish all your education. Second, this applies even if you don't take out new loans for that additional education. Third, there's no separate timeline for loans from earlier degrees or programs. What matters is when you last stopped being a student, not when you took out each loan. But there is hope if you're struggling. Even if it hasn't been 7 years, you can apply for a hardship discharge once 5 years have passed since you were last a student. To qualify, you need to prove you've made good faith efforts to repay. You're facing significant financial hardship that will continue. There are also other options, like the repayment assistance plan, that can lower your monthly payments based on your income. Every financial situation is unique. If you're in the Greater Toronto area and struggling with student debt, I encourage you to reach out to either Ira Smith or Brandon Smith, who can help you understand your specific options. Remember, getting expert advice is the first step toward taking control of your financial future.